We talked about a new law that was passed at the end of 2022, but was not taking effect until 2024. And that is the prohibition on discriminating against employees for off-duty marijuana use. Basically, off-duty marijuana use is now a protected classification in California, similar to age, race, religion, etc. So, what does that mean for employers? Number one, you cannot test employees, whether that's a pre-employment drug screen or a reasonable suspicion drug screen of a current employee, for what's called metabolites. It's here's the scientific term, non-psychoactive cannabis metabolites in the system. Translation: when someone uses a marijuana product, it stays in their system and is processed for up to 30 days. So all the testing now tests to see if there are metabolites in somebody's system. And what the legislature said is you can't test somebody where it's going to test positive for off-duty use that might have occurred a week before when they're not actively under the influence. You can only test in circumstances that would identify THC in the system, which is the psychoactive cannabis metabolite. And if you test for THC and they test positive, that you can use that as a basis for taking action against the employee. Here's the problem. There is no reliable, and you can only test based on saliva for THC, but there's no reliable test right now. The legislature passed this law in 2022 and delayed the effective date on the grounds that, well, in 2 years, by that time, they'll come up with a test. Well, they haven't. So, as of right now, it would be a prohibited practice to test somebody for cannabis metabolites and then take action against them, either choose not to hire them or fire them or discipline them for a positive test. Until that THC test becomes widely utilized, my advice to employers is don't test for marijuana. Now, this law does not say that employers can't take action against people who are under the influence. You can still terminate or take action based on reasonable suspicion. For instance, I found an employee in the back. The smell of marijuana was in the air. Their eyes were red. They were slurring their words, and they were absolutely chowing through a bag of Doritos. That seems to be reasonable suspicion that maybe they are currently under the influence of marijuana. Now, the legislation also says something about you can use impairment testing, but it really doesn't define what impairment testing is. I think hypothetically, you could train people to conduct the kind of testing that a law enforcement would use if they pulled somebody over and suspected them of being under the influence of marijuana. Walk the line, point your finger, whatever. Before I would advise somebody on taking action based on an impairment test, I would highly recommend that there be some really, really significant training for the people who would conduct that impairment testing. But I mentioned it that the law does allow that. My advice to people is, unless you have really, really good evidence of reasonable suspicion, I would not terminate somebody for suspected marijuana use at the present, because I know there's going to be a ton of lawyers looking for cases to sue under FEHA over. So just be careful with that. Now, here's the final kind of twist, right? Does this apply to religious nonprofits? Well, as I mentioned previously, religious nonprofits are excluded as employers under the discrimination sections of FEHA. And this is in the discrimination section of FEHA. So my read on it is it would not apply to religious nonprofits. Now keep in mind, That religious nonprofit designation is pretty specific, right? Just because you are a religious employer in general does not necessarily mean you fall within that exclusion. So again, this is one where if you were going to take some action against somebody for suspected marijuana use, and you say, hey, FEHA doesn't apply to us, make sure you get guidance and counsel. Don't try to put Humpty Dumpty back together again after the fact. Before you take action, get counsel on that particular issue so you can make sure that you're not taking on any liability.